Hala, nag-chat attorney. Make a video presentation reciting 117. Be creative, informative, and follow what is provided under the rules. Deadline subong? Alas 5. May discount ka, paubos ko.
Tarang kita attorney kay makagto ko danay sa lugar nga malinong. Rule 117. A motion to quash is a critical defensive pleading available to an accused in a criminal case to challenge the validity of the complaint or information before entering the plea. Section 1. Time to move to quash. Any time before entering his plea, the accused may move to quash the complaint or information. Section 2. Form and contents. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion except lack of jurisdiction or over the offense charge. Section 3. Grounds. The accused may move to quash the complaint or information on any of the following grounds. A. That the facts charged do not constitute an offense. B. That the court trying the case has no jurisdiction over offense charge. C. That the court trying the case has no jurisdiction over person of the accused. That the officer who filed the information had no authority to do so. E. That it does not conform substantially to the prescribed form. F. That more than one offense is charged except with a single punishment for a various offenses is prescribed by law. G. That the criminal action or has been extinguished. H. That it contains avertments which, if true, would constitute a legal excuse of jurisdiction. And I. That the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. Section 4. Amendment of the complaint or information. If the motion to quash is based on the alleged defect of the complaint or information which can be cured by the amendment, the court shall be ordered that an amendment be made. If it is based on the ground that the fact charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by the amendment. The motion shall be granted if the prosecution fails to make an amendment, or the complaint or information still suffers from the same defect despite of the amendment. Section 5. Effect of sustaining a motion to quash. If the motion to quash is sustained, the court may order that another complaint information be filed except provided in Section 6 of this rule. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made or having been made, no new information is filed within the time specified in the order within such further time as the court may allow for good cause. If in custody, shall be discharged unless he is also in custody for another charge. Section 6. Order sustaining the motion to quash not a bar to another prosecution exception. An order sustaining the motion to quash is not a bar to another prosecution of the same offense unless the motion was based on the grounds specified in prosecution 3, paragraph G and I of these rules. Section 7. Former conviction or acquittal, double jeopardy. When the accused has been convicted or acquitted, or the case against him dismissal or otherwise terminated without express consent by the court of competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to charge the conviction or acquittal of the accused or the dismissal of the case shall be barred to another prosecution of offense charge for any attempt to commit the same frustration thereof, or for any offense which necessarily includes or necessarily included in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for offense which necessarily includes the offense charged in the former complaint or information under any following instances. A. The graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. B. The facts constituting the graver charge became known were discovered only after the plea was entered in the former complaint or information. C. The plea of guilty to the lesser offense was made without consent or prosecutor and of the offended party except as provided in Section 1, paragraph F of Rule 11. In any of the foregoing cases where the accused satisfies or serves in whole or in part of the judgment, he shall be credited with the same in the event of conviction for the graver offense. In any of the foregoing cases where the accused satisfies the serve in the whole in a part of judgment, he shall be credited in the same in the event of conviction for the graver offense. Section 8. Provisional dismissal. A case shall not be provisionally dismissed except with the express consent of the accused with a notice to the offended party. The provisional dismissal of the offense, punishable by imprisonment not exceeding 6 years or fine or any amount or both, shall become permanent 1 year after issuance of the order without the case having been reviewed. With respect of offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been reviewed. Section 9. Failure to move to quash or to allege any ground therefore. The failure of the accused to assert any ground of a motion to quash before his pleads to the complaint or information, either because he did not file a motion to quash or failed to allege in the same said motion, shall be deemed a waiver or any objection based on the grounds provided for in paragraph A, B, G, and I of Section 3 of these rules.